in the Rawlsey's district. So.
Okay, well, you can't get appointed when one of them leaves unexpected.
We are live.
Okay. All right, is Stuart Shore or somebody from Dale?
Stuart is,
I am here.
Stuart.
Hello.
Hello,
Good
Stuart.
morning,
Thank you
folks.
for joining us.
Absolutely.
We're just asking if the Department of Aging and Independent Living, Disabilities, Aging and Independent Living has any comments on H-655 regarding sealing and criminal history records and access to those records.
Yes, well, thank you so much for the invitation and to address this. For the record, Stuart Shore, General Counsel for the Department of Disabilities, Aging and Independent Living, Dale. I'll make my remarks brief. I did just share moments ago with Ben, and I hope that brief memo has been circulated. At the end of my brief testimony, I'll ask the committee to take a quick peek at what we're proposing to address those concerns. But I know the committee has already heard from DCF, and more specifically, the Commissioner's Registry Review Unit last week. And while DCF and Dale follow slightly different paths to substantiation determinations of child and vulnerable adult maltreatment, there are many similarities in the department's processes, and to a great extent, the two statutes do align. Specifically, both departments receive and screen intakes. They conduct assessments and investigations. They provide opportunities for an independent review, which is immediately followed by placement on the registry of an individual when that substantiation is affirmed by the independent reviewer. Now, information on a registry is confidential, APS information, just like it is at DCF, and it may only be disclosed to statutorily authorized individuals and entities and under specific circumstances and conditions. An individual whose name is placed on the adult abuse registry may apply for expungement from the registry at any time. And if the independent reviewer upholds the substantiation, the individual may appeal that determination to the Human Services Board, and then, if desired, on to the Vermont Supreme Court. Specifically, though, Dale does, as DCF does, but much less frequently, APS often engages in joint investigations with law enforcement who may be conducting criminal investigations that arise out of the same incident that's being investigated by APS. APS's objective in conducting those joint investigations with law enforcement are similar to those articulated by DCF, and that would be including to protect the vulnerable adults and witnesses from repeated trauma and multiple interviews, and to share the expertise that can be provided by law enforcement. And like DCF's records, Dale's APS records are confidential. I mentioned the registry records, but all of its records are confidential, and absent a court order can only be disclosed to statutorily identified individuals and entities. So just as DCF has noted, Dale, and more specifically Adult Protective Services, requires access to its retained records after expungement and sealing, and the ability to use and disclose them as required in pursuit of a substantiation. So Dale may not know that a case has been sealed and expunged. And I think the most significant position that Dale has, a concern that Dale has, is that if a criminal case is dismissed or a defendant is acquitted at trial, APS may still wish to proceed with its investigation and substantiation of the maltreatment of that vulnerable adult. But APS's ability to substantiate those allegations of maltreatment may rely in large part on its ability to access materials gathered by Adult Protective Services during its joint investigation with law enforcement. And expungement and sealing those criminal records, expungement and sealing make those criminal records unavailable for use by APS. So for the same reasons articulated by DCF, we would propose language that looks like what's in the memo, that clearly identifies that those records that are gathered by Adult Protective Services during those joint investigations are in fact records of the department, and they may be continued to be available by the department when continuing its investigation, notwithstanding what the criminal justice system may do with that particular matter. So I welcome any questions that you may have.
Are there questions for Stuart? Senator Bowski?
I guess my question is, what is the sort of current status quo in terms of your access to expunged or sealed records?
At this point, I'm not aware of us being denied anything that we may need, but the concern is that if records are in fact sealed or expunged, we wouldn't have access to them anymore. So I don't.
Okay.
When there's no criminal charge brought under this bill, that record is sealed, I believe. That's where the concern is expressed.
That's
because
right.
Your standard of putting someone on the abuse registry is different from a criminal standard of
That's right.
beyond a reasonable doubt.
Right.
And
we have to prove by preponderance of the evidence, much lower standard.
Is to protect vulnerable populations from people who may work with those vulnerable populations, who may abuse those populations. Fraud would be a good example of somebody who might not be good to work with a population that you deal with, Dale.
Right.
So while fraud investigation may not prove beyond a reasonable doubt that defrauded somebody, but your standard is different. That's basically what.
That's right.
I'm more familiar with the DCF than yours. How many people are on your registry?
Oh, well, I don't know. I don't have a count. We have tens of thousands of requests a year to check the registry. But there are individuals who are placed there as a result of substantiations. There are also individuals who are placed there as a result of a conviction for abuse, neglect, or exploitation of a vulnerable adult under Title 13. So
your substantiation is different from the criminal. They may not have been found criminal guilty, but you substantiated the abuse.
That's right. It's a separate administrative process.
I guess what I'm trying to understand, because currently we have a system of expungement and sealing, and I guess what I'm trying to understand is if this is currently a problem, or if it's the expansion of that system proposed in this bill that creates the problem.
There isn't a problem now that I'm aware of. I think it's the expansion where there's no clarity that those records would be continue to be available. And I think that's really what we're asking for, is that if not so much the conviction of an individual, but when a case is dismissed or an individual is acquitted, so there's no waiting period, is my understanding of the reading of the bill. If there's a conviction, there is, depending on whether it's a misdemeanor or a felony, there's a waiting period before the individual can seek the sealing. We don't anticipate that in many cases that would impact APS's ability to continue with its investigation.
Okay.
However, if there's an acquittal or charges aren't brought and there has been a joint investigation, APS still needs to have access to the records that it acquired while working with law enforcement during that investigation.
Okay, thank you for helping me to just understand how it interplays with the current system versus what's being proposed here.
Sure.
Okay. Any other questions for Stuart? Stuart, thanks much. We'll start marking the bill up tomorrow, and we'll be sure to discuss your amendment as well as DCS.
Great. Thank you, Senator. Have a great day, everyone.
Thank you. Have a good day.
Thanks. Bye-bye.
Now we're going to change gears, change counsel. And we're going to do retail theft, something we all understand.
Tucker, do you have a card?
You're not gonna start with that.
Phone number?
I'll give you mine, you can write it down.
Right?
Well, I don't think the bill's gonna make it,
I'll just send you a
to be honest
text.
with you.
I think it's too, yeah, I agree.
How about,
So,
how about I do like.
so I don't wanna
just like a-
waste your time.
I appreciate that. So I'm gonna I'll think about a list of just kind of the decision points for y'all, and then we can talk about them and ultimately.
Nice.
And then, you know, if you want me to continue on it after tomorrow, I can.
Yeah, I just can't see us we're running out of, we got 2 weeks left. And do I put the time into bills that will make a difference, or put the time into bills that are gonna
Because
get
what
beat up?
DPS is in here is asking for you to get rid of super sealing and for them to have access forever. And you guys are like, no, we don't think you should have access for
At all.
10 years.
Yeah.
Unless it's by court order, so.
The one thing I'm gonna rely.